Notice the defense attorney's calm tone. It's a calculated move to gain trust. He isn't just speaking to the judge, he's speaking to the jury's emotions. In trials, persuasion isn't only about facts, it's about delivery. Do you think his strategy will win sympathy
Right out
or
of the
raise
gate,
suspicion?
the judge is not holding back. Punching your own mother? That's one of those charges where the emotional weight hits harder than the legal jargon. Let's break down why this case just went from bad to worse.
The courtroom falls silent as the prosecutor steps forward. Every eye is fixed on the evidence table. This moment could decide the case. Will the jury believe the documents or see them as weak? Stay alert. Justice often turns on the smallest details hidden in plain sight.
I mean, don't do this thing where we're shaking our head, we're trying to consider, because what I just read is you punch your mom in the mouth. We only get one mother, and it says that she was bleeding. I mean, if you want a jury trial, I'm here.
That part is announced for
Anybody
the
who wants
record
a
for the
jury trial is
state.
more than
Ruben
welcome.
Herrera for the state.
Defense.
For defense?
And are you Mr. Ronnie Simmons?
Yes.
Mr. Simmons, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonition.
An objection is raised. Classic courtroom tension. Objections can disrupt rhythm, challenge credibility, and reshape arguments. Watch closely. If the judge sustains, the jury may disregard vital information. If overruled, the opponent gains momentum. This single word, objection, can shift the entire balance of justice in seconds.
Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand what you're charged with is assault, family, second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison?
The witness takes the stand, nervous hands trembling. Authenticity is key here. The jury studies body language as much as words. Does this person radiate honesty or hide something? Courtrooms don't just test memory, they test credibility. Would you believe this witness if you were sitting in that jury?
And up to a $10,000 fine.
Quick legal insight here. Assault family second offense isn't just another assault charge. Because it's family-related and a repeat offense, Texas law bumps it up to a third-degree felony, meaning prison time is very much on the table.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Showing you the plea bargain page, did you review that case? Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is recommending deferred adjudication. And
Listen carefully to how evidence is introduced. It's not random. Every piece is strategic. Lawyers build narratives like puzzle masters. One missing piece, and the story collapses. The jury must decide if the evidence connects perfectly, or if gaps exist. Do you think the puzzle looks complete or broken?
Mr. Simmons, did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, sir.
State, is that the plea bargain agreement?
It is.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, no contact with Cheryl Simmons, no harmful or injurious contact with Ronald Simmons, and of course, there's an affirmative finding of family violence. I know that you all have put affirmative finding of family violence below the line, but if I deem that this is a family violence case, there will be an affirmative finding of family violence. Does everyone understand?
Yes, sir.
Cross-examination begins the lawyer's battlefield. Questions are sharp, designed to trap inconsistencies. The witness struggles, hesitations growing louder than words. This is where truth cracks or solidifies. Audiences love this part because it feels like a duel. Who do you think will walk away stronger after this exchange?
All right, other than that, did everyone understand that I don't have to follow the recommendations from the state? Did you understand?
Yes.
All right, then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Okay.
State, any evidence?
The state offers State's Exhibit 1 and all attachments, Your Honor. No objections, Judge.
Court will accept into evidence State's Exhibits 1 and attachments and review the same.
The judge leans forward, signaling authority. Every word matters. Judges often shape the courtroom atmosphere without saying much. Their silence can be heavier than speeches. Respect for order keeps chaos at bay. Imagine being in that room. Would you feel safe under this judge's control or intimidated?
All right, I review on State's Exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right, so first question I have. Ronald Simmons, Is Ronald Simmons married to your mom, and do they live together or no?
Father, actually, Judge. And
Right.
I think the surface will never get it.
So they live together. How old are you?
32.
You're 32 years old.
Did you catch that? The judge literally had to ask a grown 32-year-old man why he's hitting his own mother. And when the defendant just shakes his head.
Notice how the jury reacts: subtle nods, raised brows, shifting eyes. Juries are the heartbeat of trials. Lawyers often watch them more than witnesses. Their reactions reveal hidden verdicts forming. It's a silent conversation between courtroom and conscience. If you were a juror here, which side would you lean toward?
That silence speaks volumes. What excuse could possibly make sense here?
Is this complaint in this case your biological mother?
Yes.
Why are you hitting your mom? I mean, don't do this thing where we're shaking our head, we're trying to consider, because what I just read is you punch your mom in the mouth. We only get one mother, and it says that she was bleeding. I mean, if you want a jury trial, well, I'm here. Anybody who wants a jury trial is more than welcome to have it. But it appears that you have some anger issues because this is a family violence second. This is not a first.
Closing arguments arrive. This is storytelling at its peak. Lawyers weave law with emotion, facts with passion. This isn't just about winning. It's about convincing ordinary people of truth. Think about it. If you heard both sides today, whose narrative would echo in your heart when deliberations begin?
How old is your mother?
46.
When's her birthday?
May 30.
You sound very unsure. All right. So why are you hitting on your mom? All right. And at your age, even if you were younger, if your parent doesn't want to drive you somewhere, they don't have to. That's what via buses are for. That's what getting a job and getting your own car for. When this happened, were you living at that home?
No.
So you're coming over starting problem. In this previous assault family violence case, who was the complainant in that case? On March 25th, 2022, you were convicted of assault, bodily injury, family household, and cause number 669.
The verdict is near the most intense moment. Tension is thick, silence louder than thunder. Every second feels eternal. One decision can alter lives forever. Justice isn't abstract here, it's human, raw, final. As you watch, ask yourself, would you trust 12 strangers with your own fate today?
9877. Who were you on probation for out of that cause number? What is their relationship? Can somebody look that up for me? Cause number 669877. It's a county court cause number, and see who the complainant was.
Cheryl Simmons.
Cheryl Simmons.
Yes.
So, the same person.
Now here's the kicker. This isn't even the first time. The same mom was the victim in a previous assault. That history means the court sees a pattern, and in family violence cases, repeat behavior.
The verdict is read, the courtroom breathes as one. Relief, shock, angry emotions clash instantly. Justice doesn't satisfy everyone. It rarely does. What matters is the process, the fairness, the fight for truth. Remember, trials don't just end stories, they begin new ones. So, what's your verdict on this case?
Behavior almost guarantees harsher conditions.
What is your issue with your mom? I don't understand people who hit their mothers and their parents. As you know, I'm from the old school of parenting. That most definitely would not have been allowed. And there are many things that I could not say, but I don't know if, well, I do know. If I would have hit my mom, well, let's just say I would not be here as judge now. But people would probably be saying, oh, we remember Stephanie. She was such a nice little girl. So why are you hitting on your mom? And this is not the first time. There has to be a reason for it. Why do you think it's okay to hit your mother?
I mean, I could sit here and say I didn't, but I mean, been no contact, so.
Well, no, I mean, you've done it before in the past, so I'm trying to figure out why you're hitting on your mom. Why do you think that's okay? Oh, you want a jury trial?
No, I'm just answering your question.
Well, we have 2 cases with you involving your mom. So you're saying on both occasions, you never put your hands on her. And the fact that they're saying that she's bleeding from the lip, that's just, I don't know, something she did to herself. All right. And it says here you hit her with a closed fist, splitting her upper lip, causing it to bleed and swell. It says suspect grabbed victim's left upper arm with his left hand, holding her in place, and then punched her in the mouth with closed fist. And all of this because you wanted her to drive you to the store, and she said, no, walk.
And all of this over a ride to the store? The judge calls him out here, like, ever heard of walking the bus or getting your own car? This moment is where the courtroom shifts from legal to downright embarrassing.
I don't know what people, in this day and age, people act like children can't ride the school bus. They got to have a nice car. People can't walk to where they need to go because it's embarrassing or get on